Well, good evening, everyone. We'll at this time commence the February 18th, 2026 Minimum Housing Standards Commission meeting at 17:31. We'll begin with the approval of minutes from the meeting on January 21st. Do we have a motion?
Motion.
Motion with Commissioner Jones and seconded by Commissioner Furlow. All in favor?
Aye.
Any opposed? That passes as the approval of minutes. Moving on to the request of staff for any changes to the agenda.
There are no changes.
And now on to swearing in of city staff to testify.
Please place your left hand on the Bible, raise your right. Do you swear or affirm the testimony you give in the following matters will be the truth, the whole truth, and nothing but the truth?
Yes. Yes.
Thank you. Please proceed.
And now on to the swearing in of owners, citizens, and other testimony.
Do you swear or affirm the testimony you give in the following matters will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed.
Before we commence with the public comment period, I would ask that everyone in the room, for the purposes of this meeting, please mute and/or silence your cell phones to prevent any interruption of the meeting. Now on to the public comment period. The Housing Commission is a quasi-judicial board. Therefore, speakers may only address in general the minimum housing standards or affordable housing in Greensboro. Speakers may not address any property that is currently under investigation or may be under investigation. Speakers who attempt to discuss a specific property other than as allowed above will be asked to end their comments. Each speaker is given 3 minutes. Staff will provide the speaker with a 10-second warning before the time expires, and then the mic will be turned off. Begin. Case of 1718 McKnight Mill Road. Case number 2. Forgive me, I terribly apologize.
Sorry.
Just moving through. Do we have any who wish to comment? The floor is open to you at this time. Please identify yourself.
And Mr. Hawkins, if I may, real quick, just before Mr. Hawkins speaks, just to reiterate something you said earlier, of course, I want to underscore the fact that the public comment period is more generally open. Once we transition to the quasi-judicial hearings, of course, we are, in a quasi-judicial setting at that point and would need relevant testimony from folks speaking. So I just want to make sure that distinction is clear for everybody in attendance.
It is. Thank you.
So I'm not testifying as we speak. I'm not testifying there.
Public comment period, yes, sir. It's just
Fair enough. Just
To answer your question, sir, no, you are not testifying.
thank you.
Certainly, sir.
George Hartzman, Public Integrity Watch. The only reason I knew there was a meeting today was because there was an article in Yes Weekly, written by that fellow, I believe, over there, about the district, evacuation and whatnot. Since that happened, I've done a whole lot of public records requests. Some still haven't been returned, which is, I guess, not surprising. But what I found is that cases are being prevented from coming to this board. And a lot of those cases, from my understanding, are it's multifamily. And from emails that I've read, multifamily is something that's got an A or a B or a 1 or a 2 or a 3, right? Different floors, that kind of thing, like the district. Ian talked about a woman named Crystal lived at the district, and she had pictures of black mold all over the place. And I got an email from Larry Roberts that said, we don't deal with black mold. But black mold is caused by plumbing, right? So you do deal with it. You know what it looks like. Unfortunately, it appears that you have been prevented from doing your jobs by city staff. Is that how it went down? I mean, how is it that you got all these rental properties with all these problems? I looked them up, and I've written about them. Nobody cares, really, which is sad. But this is months now. Nothing. We got what? We got a city council person here. But I mean, has anything been fixed? Have you fixed anything? Have you done anything?
Chair Hawkins, I apologize.
I don't know how.
Cole was keeping time. Mr. Hartzman's 3 minutes have elapsed at this point. I'll defer to you as the chair.
The clock's not on.
Ms. Holt's been timing it throughout, Mr. Hartzman. I'm not sure if we can get the clock going separately, but...
All right. So I'm talking on number 6.
Thank you, Mr. Hartzman, for your comments. Are there any additional public comments at this time? With nothing else or anyone additional, close the public comment period and move forward to requesting an ordinance to effectuate compliance. That being the case, 1718 McKnight Mill Road, case number 23-003907, parcel number 43839.
So for 1718 McKnight Mill Road, the date of initial inspection was July 16th, 2023. There was a hearing on April 12th, 2024. An order to repair or demolish was issued on April 29th, 2024. It expired on May 29th, 2024. The property did not have to be secured. There are children in the area. There is not a school nearby. This was originally in order to repair repair. However, there was a fire there on February 11th. And so the inspector went out there on February 12th and updated some additional information. So it's moved to an order to demolish. Angela DeBose is here to speak on the inspector for that property.
Chair Hawkins, if you'd like, I'd be glad to ask the inspector a few questions to get us going, and certainly defer to the board on any follow-up questions they may have.
Proceed.
Yes, sir. Inspector, can you state your full name for the record again, please?
Her name is Angela DeBose.
Thank you. And are you the one who inspected the property and documented the violations?
I am.
Okay. And I know there's been a video running. Does that video accurately depict the condition of the property when you inspected it?
As it currently is now, yes.
Okay. And can you again just speak to that current condition a little bit more, the nature, the extent of violation that would be present?
Well, at first, the owner did appear to be making repairs to the house. Believe it or not, she had brand new windows in there. The floor had been stripped as if she was getting ready to furnish it. There was a hole in the ceiling that was repaired, but then after that, everything seemed to stop. I have been in contact with her a couple of times. We did another inspection because there's just been no contact, and so I needed to get some updated information and plus prepare the property to go to the minimum housing. At the time, there was no fire, so the house was closed up. It was sealed off and everything. There was no issues besides just the regular stuff that has not been repaired, and that's why we prepared it for order to repair. But then, as stated, the fire took place. We went out and did another reinspection, and we found that the damage was more extensive. And so, adding it up, I think the total was 81%, I believe, of the damage. So we changed it to order to demolish.
Yes, ma'am. Thank you. Chair Hawkins, I defer to any questions that the board may have at this moment.
Fellow commissioners, questions, remarks? We're ready to proceed with the vote.
Motion to uphold the inspector's order to demolish.
I'm speaking on this.
Is there a second?
Second. Chair Hawkins, if I may, real quick, I wasn't sure if Mr. Hartsman indicated something about wanting to speak on the item. I'm not sure if he has factual testimony that's relevant or not. I wasn't sure if we were closing the public hearing at that stage, but I'll defer to you as chair. How you want to approach it?
We will indulge.
And again, I will just preface it by saying, of course, we would need factual testimony relevant to this property, so.
Before you proceed, Mr. Hartsman, is it relevant to this specific case? Or?
Yes.
Very well, sir. Proceed.
So when was the initial complaint?
Before you proceed, hold that for just a moment.
I have a question for clarity to staff. What would qualify his statements as being factual?
Would relate to the condition of the property, personal knowledge of the condition of the property. That's the basis of the request from staff that's in front of y'all. I believe Mr. Hartsman led in with a question about when the initial complaint was filed. I don't see how that's going to bear any relevance. Again, he's able to, as a member of the public, if he has factual testimony, as a witness, he's able to show up, give testimony based on that knowledge. But to appear and simply ask questions in a quasi-judicial hearing, that's not something that a general member of the public would have standing to show up and do. So, again, factual testimony, I think we can talk about that, but I don't know that that's where we're headed so far from Mr. Hartsman's comments.
Yeah, I think I'm just wondering, what then, is there a series of questions that we vet members of the public when they speak in this quasi-judicial portion of our meeting to understand if their testimony is factual or not?
Typically, I would say, it's just a matter of letting them get up and usually start to speak with any factual testimony that they believe they have. So far, I've got a question, not any facts related to the conditions of this property based on firsthand knowledge. If it were to continue down that path where I'm not hearing factual testimony based on personal knowledge, it would be my advice to the board that we have the testimony cease at that point. But of course, as chair, Mr. Hawkins, I'd have to defer to you on that decision. I would just advise.
Sir, additionally, typically, we do have a commissioner who is a realtor, so has a specific set of skills as it relates to how to some strong degree, verify or validate or invalidate statements. Yes.
Yeah, I think I was just, factual is just so broad, and I was just wondering, professional knowledge, realtor, inspector.
Sure. For a little bit of clarity, Commissioner Trump, if we were talking about somebody who was popping up with expert testimony, I think that would be one thing. But again, just factual knowledge of a given situation. I think what we'd be looking at is, a neighbor who is personally familiar with the condition of the property because they've been there, seen it every day for X number of years, live right next to it, that sort of thing. But even then, repetitive testimony in a quasi-judicial setting is also not necessarily, the board does not need to entertain repetitive testimony. So if we have sufficient information about the nature and extent of the issues at the property, it's also within the chair's purview to say, I think I've got what I need.
As we proceed, I just wouldn't hope that the board comes under scrutiny for nefarious practice because we are allowing testimony, the commissioner board here, from a source that we don't know is actually factual. However, I do err on the side of hearing from the public. I just want to make sure that we are following the procedures.
Yes, sir.
As outlined, because that could put us under scrutiny in this portion of the meeting.
Yeah, and I would reiterate, Mr. Hartzman thus far has posed one question. That's not factual testimony. If he intends to pivot to factual testimony that is based on personal knowledge of this property, wonderful. If not, my advice would continue to be, it doesn't seem like factual testimony relevant to the quasi-judicial hearing. Let's move forward.
By all means, Mr. Hartsman.
Am I allowed to ask a question?
As a member of the public, Mr. Hartzman, again, you are able to appear in a quasi-judicial setting and provide factual testimony if it's based upon personal knowledge. If you don't have that, your participation in the hearing is nil.
Am I allowed to ask a question?
So, once again, no, unless someone were to establish standing as a party to a quasi-judicial action, which I don't see how we would get there. Again, you would be limited to making statements of giving factual testimony based on statements related to your personal knowledge.
Am I allowed to ask a question?
I believe I've said no 3 times now.
No, I'm not allowed to ask a question.
Factual testimony, sir.
This case came up in 2023, sounded like.
Which was already read into the record, Chair. If you think that's repetitive, I mean, you can say that's the end of the testimony if he's got nothing further.
What?
Repetitive testimony.
I just stated a fact. And then there was a demolish order the next year.
Before you proceed.
That's 2024.
Before you
Wait a
proceed,
second.
Mr.
It's
Hartsman.
2026.
Mr.
Your meeting,
Hartsman,
Chair.
before you proceed, bear with us a moment here. Because of the uncertainty of the direction that Mr. Hartsman is taking. I don't want to be presumptuous in judging that, so Mr. Hartsman, proceed.
Thank you. It looks like the only reason that this case is before the commission is because there was a fire a week ago. This house was in terrible shape. It should have been taken care of at least a year ago. And it's now before the commission because there was a fire there.
Chair Hawkins, once
See,
again.
now I'm not allowed to say, well, what happened? But what happened?
Mr. Hartsman's personal
So,
sentiments on the matter are not.
my
actual
objection
testimony. My objection
to this,
his testimony and my advice
item
still stands.
is based on
Mr. Hartsman,
the lack of action
Mr.
by
Hartsman,
the city of Greensboro to take care of its housing stuff.
Mr. Hartsman,
Thank you. I'm
certainly,
done.
sir.
I'm done.
I couldn't understand what was being said because multiple parties were speaking. And rather than to have the two of you go on simultaneously, I wanted to ask you to pause a moment so that I can actually indulge City Attorney's Office representative and then return to you. But you have
Okay.
indicated that you have concluded.
I have.
Very well, sir. You were about to, you were in the midst of saying that.
My apologies, Chair Hawkins. All I was trying to get at again is that personal sentiment on sort of a timeline involved in a case is not personal knowledge, factual testimony that's relevant to the items in front of you. You all have the timeline. Feelings about a timeline are not factual testimony. So,
Is there a question from city staff?
Yes, I don't mean to keep this going on. We did not get Mr. George's last name or his address. So I would like to get that for the record, please.
Mr. Hartsman, if you please approach the podium.
My name is George Hartsman. My address is on file. The city is well aware of my address. Thank you.
Thank you, sir.
My fellow commissioners. Thank you. Motion was set forth by.
Chair Hawkins, have we actually closed the hearing? I'm sorry, I think we want to make sure we go ahead and do that.
I may have skipped a couple steps. Thank you.
Before we proceed with that motion, does anyone have any remarks of any kind so that we're clear and it has been stated as such? You raise your hand, Commissioner Fisk. Very well. No comments with regard to this particular case. Close it at this time. Motion.
Motion to uphold the inspector's order to the model.
Second. That has been introduced as a motion by Commissioner McCaskill and seconded by Commissioner Jones. All in favor?
Aye.
Any opposed? That passes to demolish. So, Commissioner McCaskill, if you would take that motion. That's on the agenda. That appears above number 6.
I move to uphold the inspector's order to demolish and adopt an ordinance to demolish and to allow staff to seek a summary ejectment of any occupants remaining in the condemned property and to petition the Guilford County Superior Court to appoint a qualified receiver.
And for future reference, gentlemen, that needs to be read as property involved in this matter is located at 1718 McKnight Mill Road. The property owner and all properties in interest in said property have been properly served with all complaints, notices, or orders issued in this matter in compliance with the law. The property owner and all parties in interest were afforded their due process rights in compliance with the law. The property in question has more than 5 separate types of violations of any of the minimum housing standard code, without. The property in question has more than 5 separate types of violations of any of the minimum housing code standards, and the cost of repair said violations is greater than 50% of the value of the structure. The continuation of the dwelling in its current condition is detrimental to the health, safety, morals, and welfare to the people within the city of Greensboro and is unfit for human habitation. Based upon the foregoing findings of fact, it is hereby concluded that 1, this matter is properly before this commission. 2, the described structure is dangerous and unfit for human habitation. And 3, the order of the inspector is proper in all respects. Therefore, it is ordered, resolved, and decreed by a vote of this commission that the inspector's order to demolish is upheld this, the 18th day of February 2018. On to 2105 Van Wert Street, case number 24-003960, parcel number 26567.
For 2105 Van Wert Street, the date of initial inspection was July 10th, 2024. There was a hearing on September 25th, 2024, expired in October of 25th, 2024. The property did not have to be secured. There are children in the area. There is a school nearby. There is not a history of police complaints. The city is seeking an order to repair, as the estimated cost to repair is 22% of the tax value. And Inspector Matthew Peel is here to speak on that for Zach Lewis.
And again, Chair Hawkins, I'd be glad to lead with some questions and defer to the board after that.
Proceed.
Yes, sir. Inspector, can you state your full name for the record again, please?
Yeah, Matt Peel, Field Supervisor for District 1 Code Compliance.
Appreciate you. And of course, we do have video that has been playing. Does that video accurately depict the condition of the property when y'all
Yes.
inspected?
Yes.
All right. And as it's playing, can you kind of speak to the nature and extent of the violations that were present on the property?
Yeah, so that's the exterior video that we're showing right now, and honestly, with this case, that's most of the damage, the repair issues, soffits and gutters, downspouts, siding. There's cracks in the foundation walls, openings in the crawl space wall, issues like that on the outside. And then on the inside, it's mainly wall, paint cracking, ceiling cracking. The water's turned off, but it's been turned off for a while. So there's some backup in the toilet. So I don't know anything past that, but as far as just our visual inspection, it was mainly just trash and dirt and cracks in the walls.
Turn it off, and I thought I turned it on. Thank you, Inspector. Chair Hawkins, if the board has any follow-up questions, I would defer to y'all at this stage.
Fellow commissioners, questions, remarks?
I have just one quick question. During the inspection, I kind of see some older paint. I used to live in this neighborhood, so I'm pretty familiar with a lot of the surrounding properties, and I see the paint looks to be like lead based. Is that something that we test for when we go out to these different properties that have, I guess, been built before a certain time, so that we can not only see with our eyes, but have some type of thorough check on this lead paint and some outdated things that, you know, should be fixed or updated in every home in the community?
No, that's a good eye. We actually are beginning to partner with H&D and Lead Safe when we come across houses like this to recommend to them. It would be on, we don't have any ability in code to specifically remedy that issue or repair it or take care of it. But through Lead Safe with Housing and Neighborhood Development, they can, when we recommend houses like this, they can get involved and work that process.
Thank you.
Anything additional? And is there a motion?
Do I get to talk?
Chair,
Testify.
I'm not
I'd
sure
like to testify.
if Mr. Hartsman would.
Before you proceed, Mr. Hartsman, bear with me a moment. With regard to the note from the public comment period, does state speakers who attempt to discuss a specific property other than as allowed above will be asked to end their comments. Now, you indicated that you had testimony as it relates to this specific property, is that correct?
That is correct.
Chair Hawkins, I'd just preface it with the same comment I made earlier. If there's factual testimony based upon personal knowledge in relation to this property, okay. If there's not, my advice is going to be consistent with what you just read from the agenda script. So suppose we just kind of have to wait and see.
Proceed cautiously, Mr. Hartsman.
Would it be in line with keeping with those procedures to ask members of the public what their personal knowledge of the property is before they proceed with the testimony?
We certainly can. Usually that's going to be the content of the factual testimony, of course. So just curious to see what Mr. Hartsman may have to say, but I would defer to any question that the commissioners may wish to ask, in light of that.
I think it's possible to ask that question without proceeding with personal testimony, just asking what their personal knowledge is without proceeding with the testimony itself.
Very well. Mr. Hartsman, would you elucidate, please, sir, on your personal testimony would be, or what sort of factual information you have as it surrounds this specific case?
So you ready? You ready? Okay. 2024. This case came up in 2024. That says February 16, 2026. My testimony is on the Bible that this should never have gone on this long.
It's a matter of opinion.
My testimony is that something is very wrong with the way the Code Compliance Department does its job.
Chair Hawkins, if I may.
That is my testimony.
That has no bearing on personal knowledge of this particular property. I understand Mr. Hartsman's position, truly.
24,
Again,
26. That's my personal knowledge.
And at the very least, that is information that can be gleaned from the documents in the record. Therefore, at best, it's repetitive to what's already in there. It's not factual testimony. My advice is in line with that fact.
I see.
I would not let the comment proceed personally.
Mr. Hartzman, thank you for your remarks. Thank you for your testimony and insight. Anything additional, my fellow commissioners?
Quick question. Homes like this, are they typically padlocks so the kids can't get in, do anything?
This one in particular was locked. We had no access in. We had to contract a locksmith to get in. From the inspection on the interior, there were clothing items and items of food and things like that.
If there's a conversation that needs to be had, please be discreet and do so outside of these chambers. Proceed.
Thank you. So there were articles of clothing and items of food inside, but nothing to indicate easy access for children.
Very well. We have a motion.
I am happy to move that. Follow your admonition the last time. I want to make sure I state the right language, and it's not here as it was for the demolition. So, oh, here, oh, okay.
Just these words instead of the order to, as opposed to order to demolish. This,
The whole thing.
no, just,
Okay.
sort of purpose.
I move to uphold the inspector's order to repair and adopt the property at 2105 North Street.
And
Is that correct?
to allow staff to see this in the agenda.
I think this, the sections for this, because of the indictment and the petition to Gilbert County Superior Court to appoint a qualified receiver for demolish only. So we will just motion to uphold the order, the inspector's order to repair, or do we need to read out?
I'm fine with that motion as stated.
Second.
All right. That has been introduced by Commissioner Furlow and properly seconded by Commissioner McCaskill. All in favor?
Aye.
Any opposed? And that goes forward as an ordinance to repair. The property involved in this matter is located at 2105 Van Wert Street. The property owner and all parties in interest in said property have been properly served with all complaints, notices, or orders issued in this matter in compliance with the law. The property owner and all parties in interest were afforded their due process rights in compliance with the law. The property in question has more than 5 separate types of violations of any of the minimum housing code standards, and the cost to repair said violation is less than 50% of the value of the structure. The continuation of the dwelling in its current condition is detrimental to the health, safety, morals, and welfare of the people within the city of Greensboro and is unfit for human habitation. Based upon the foregoing findings of fact, it is hereby concluded that, 1, this matter is properly before this commission. 2, describe the structure is, the described structure, is dangerous and unfit for human habitation. And 3, the order of the inspector is proper in all respects. Therefore, it is ordered, resolved, and decreed by a vote of this commission that the inspector's order to repair is upheld this, the 18th day of February 2018.
Chair Hawkins, I think you may have misstated the year.
Oh, excuse me, 2026, 18 February 2026. Forgive me, I apologize. Sorry, I left the meter running on the DeLorean. My apologies.
Chair Hawkins, if I may, I think we're ready to pivot to the next part of the agenda, but before we do it, I just want to put a finer point on something that I was articulating during the last two hearings. Quasi-judicial hearings, again, you need factual testimony based upon personal knowledge. Something that is an opinion, however we may feel about it, however much we may agree or disagree, something that is an opinion, something that is speculation, something that is not just a statement of fact based on personal knowledge. I live next to this property and I see it's in the same condition that the inspector just spoke to. That is not supposed to be included in a quasi-judicial proceeding. It's important that we maintain the record in that way because these things get appealed to Superior Court, right? It is meant to proceed like court. It is a stark contrast from legislative hearings where broad public comment, opinion carries the day in those kinds of comments. This is just a very different process, and I know it's frustrating contending with it sometimes, but I just don't want anybody to lose sight of that distinction.
Thank you. I'm inclined to agree. I didn't want to be presumptuous in where any person who wishes to make a public comment is going, just afford them a little latitude, but in that case, that was more than a momentary indulgence. Going forward, we will proceed very differently.
I would just ask, it's really a reiteration of the question that I had earlier because I'm quite familiar that, when you enter into a quasi-judicial portion of the hearing, it does become a matter of record and it can be appealed to the court level. And so I think what is not clear to us in here tonight is how then are we vetting persons who step to this podium with a comment or a testimony. He had comments, but it should have been a testimony. How then, what is the procedure that we should follow to know if we should be hearing from an individual?
Yes, sir. And regrettably, some of it is sort of we have to see what the nature of the comment will be. I think sort of as the comments proceed, we may be able to ask some clarifying questions to help us get to the final point. But sometimes I sit with other quasi-judicial boards of the city and have seen folks get up there who live in close proximity to a property. And so I'm thinking, okay, they're going to have some factual testimony here. And they get up there and within the first 5 words are saying, well, I just feel as though, statement of opinion. It kind of reveals itself as the comment goes forward. Hey, this isn't factual testimony. It's my role as the attorney sitting with the board at that point to advise, hey, we may need to take a look at what's being stated and see if we can pivot towards something that is indeed going to be a fact based upon personal knowledge. So I'll always, look to advise you all timely on that and give the chair the opportunity to perhaps halt testimony if need be, if we're indeed not getting to any factual testimony. So.
Yeah, and on the other boards that I sit on that have a quasi-judicial process, it's a matter of just asking, are you a professional with expert testimonial knowledge? Yes or no? Are you a neighbor with expert testimonial knowledge? Yes or no? Are you a realtor with expert testimonial knowledge? Yes or no? And depending upon the outcome of those questions, they can or can't proceed, which would keep us from hearing any factual comments
Yes, sir.
and preserve the record
Yes, sir.
in that case.
Yes, sir. Yes, sir. All right. Certainly understood about being able to vet a little bit on that. Yes, sir.
Per that statement, it may be prudent then, going forward, that as a prefacing statement, to ask that series of questions of those who wish to testify.
I think we certainly can. Of course, the tough part is the open-ended question that kind of comes at the end of that is, well, is there anything else you have that gives you personal knowledge? And that's when we probably start to hear matters of opinion. But yes, I think, endeavoring to narrow that scope a little bit, I think is something we can certainly do. So thank you. Yes, sir. Appreciate you, Commissioner. Yes, sir.
And moving forward, question motion to rescind ordinances for verification. That is all numbers 8 through 13. Okay, is there a motion?
Motion to rescind items 8 through 13, which are now in compliance.
Second.
All right. That motion has been set forth by Commissioner Jones and properly seconded by Commissioner McCaskill. All in favor?
Aye.
Any opposed? And that passes. Now on to, before I go on to, is there anything additional from the city as it relates to any other additional matters? All right. Close that part of the agenda and on to items from the Minimum Housing Standards Commission members. My fellow commissioners, before you give your remarks, I would like to formally welcome and announce our latest commissioner, Commissioner Drumright. Welcome. My fellow commissioners, have that. Any remarks?
Yes, I have a quick question regarding the timeline for when these houses finish inspection to making it to this board. Is there like a standard timeline in which we do things? Because there is a concern when a house has been ordered to demolish over 3 years and then it comes before us and it's still not demolished. So it's just kind of a question of, as we move to this road of 10,000, are we maximizing our opportunity to keep the housing stock that we have available, and what that looks like moving forward on the residential single family aspect, as well as on the larger residential apartments. What's the timeline? Is there like a 4 month, a 6 month, in which we can kind of move things in a timely fashion to get these houses, back on the market?
So I can answer some of that. There is a timeline if everything falls into place correctly, yes. And so I would say 3 or 4 months. However, when we're talking about, demolishing somebody's house or repairing somebody's house, which would, both acquire liens on their property, because they're still owned by the property owner. We do have to, we have to notify all parties. Where we get stuck on some of these is when it's heir property or there's, issues with like the ownership, and we have to serve all parties to make sure, we've made everybody that we know on record aware. And so that does cause some delays. Some other delays are when, they start strong with their intent to do things. and then they do not follow through. And then that's when, so we may, have been working with somebody for a while, and they have shown, intent to repair, and bring it up to minimum standards, but then it just stops for different reasons. It could be a family issue, it could be a money issue, that type of thing. And so there's multiple reasons that properties get stalled, or that there's a time, between, which was pointed out earlier today. So.
Can I add on to that as well? To add on to that all comes into play, but previous guidance we were given was we were only going to bring houses that are ready to be knocked down to the commission. That's the guidance we were given. Recent conversations, new staff, city staff, if it's ready to go to the commission, take it to the commission. So we have a backlog of cases that we're trying to get to you based on the old guidance. They're ready to come to the commission, we're trying to get there. That's why there's a lag, because we were told if it's not ready to be knocked down, the commission is not going to take it to the commission. That's why you see a lag. Apologies.
Thank you for that information. And to be clear, would you identify, quote, the old guys?
Chair Hawkins, you put Mr. Kimball in a bit of a spot there. I think his comment stands for itself. I hope we can agree.
Since this is for the purposes of public record, and one of the concerns, where there are many, one of which has been primarily transparency, again, I would ask that you identify, quote, the old guys.
Chair Hawkins, I'm assuming it would have been a collection of folks involved in conversation, including perhaps some of my predecessors, but I don't know that I can't get more specific for you than that. I don't know if Mr. Kimball can either.
Very well. So that I'm clear, so that the serving commissioners present are clear, is that can't or won't?
I can't.
Very well.
If you will recall, Chair Hawkins, I've started working with this commission within, I think, the last 4 months, maybe 5. We have 5 now? We might be. So.
That being the case, I'll ask a follow-up question. Can you put context behind the term, the old guys?
Chair Hawkins, I think that what Justin said indicated we've had a recent conversation about trying to prioritize these cases.
Before you proceed, Mr. Ducharme, I'm actually
more than that.
addressing him.
All right.
And I apologize if you took that as old previous staff.
I see.
Previous staff gave that guidance. Now, who gave that guidance, I don't know. At the time I was an inspector, but that was the guidance we were given.
Very well. Did that answer your question, Commissioner Jones, to your satisfaction?
Yes.
Commissioner McCaskill?
I just want to, as I was noticing here, there were some dates. Were these rescinded properties just brought from our previous commission? It was just like the kind of challenge of going through the system to clean out. I noticed that like number 8 was demolished in 2023. Number 9 was demolished in 2018. Was this just continued tidying up the record?
Yes, and I know it got brought up at the last, I think Commissioner Furlow pointed something similar out, and we have been trying to go through some records and do some cleanup, and yes, these were ones that were found to be in compliance, but we still had open ordinances on them. So,
Yeah, because I know there's a lot of attention around the number that are open, so I think obviously
Right.
getting those out, great,
Yeah.
thank you.
Commissioner Furlow.
Nothing.
Commissioner Savoy. Commissioner Drummond.
Good evening, everybody. Thank you for Mr. Chair and to the other co-commissioners. Thank you all for welcoming me. Here I am here by the appointment recommendation of former Councilwoman Jamila Pender. Someone had asked me how long of a process did it take for me to be seated here. And it took me a moment to remember, but the inquiry and conversations date back to 2024. So I wasn't a shoe-in, and I don't have any allegiances to anybody. I'm here to serve the public. I actually had asked to be a part of a commission or board that was, very low-flying, and I've been in the understanding and in the receipt of a lot of the activity on the board here lately. Just to the conversation that just played out in front of us, I just don't understand what happened. It was such a very simple answer. You were referring to people that used to work in the inspection.
People within the city.
Are they still employees or no longer?
No.
And that was my presumption, but it took 3 or 4 rounds of questioning to get back to that statement, and he made the statement. So I was just wondering, that just seemed very, as young folks would say, weird.
I got you.
And I just.
If I came off that way, I apologize.
Well, I wasn't accusing you of being weird. I just didn't understand what the issue was. And thank you, Commissioner Hawkins, for hammering that out, because that language is it is very broad and ambiguous, and I would want to know who is who and what is what as well. As we know, these meetings are on the record, and we also have members of the public and the press that are reporting on the goings on of this meeting. So thank you for that clarification. Thank you as well. Thank you all for welcoming me.
Finally, my own remarks. My fellow commissioners and all who are present, a document was presented to each commissioner of the Minimum Housing Standards Commission at the December meeting of 2025 with the expectation of signature. The document with the heading which read City of Greensboro Boards and Commissions Guidelines and Code of Conduct. There are 2 subject lines that I wish to reference regarding said document: positive work environment, diversity, and equity. An excerpt from this topic line opens as follows: the City of Greensboro is committed to providing a positive work environment free of discrimination, bias, and bullying. Then it later goes on to say that any conduct or action which creates an offensive or hostile environment is prohibited. Secondary bullet, rights and discipline. An excerpt from this topic line opens as follows: the following procedures are used with respect to conduct and discipline. Any conduct that interferes with or adversely affects work as determined by the chair is sufficient grounds for disciplinary action. Then it later goes on to say that factors that will be considered in determining the appropriate action include the seriousness of conduct, the member's record, the member's ability to correct his or her conduct, action taken with respect to similar conduct by other members, and any other surrounding circumstances. Now, to that end, I wish to make the following statement. which in part includes excerpts from a speech that I once heard with regard to the removal of my predecessor, former Chair Franklin Scott. Disrespect invites disrespect. When the powerful use their position to bully others, we all lose. Now, this instinct to humiliate, when it's modeled by someone in the public platform, by someone powerful, it filters down to everybody's life because it kind of gives permission for others to do the same thing. It is heartbreaking when we as humans choose to be so inhumane. We can do better, but we must choose to do so. Our residents deserve better, and certainly not anything less. The former chair of this Minimum Housing Standards Commission sought to seek better for our residents, yet rather than acknowledgement, he was removed, in my opinion, in a most atrocious and petty manner. If I choose not to speak out against such, then I would be as wrong as those who committed such a heinous act. Additionally, such an injustice to this commission not only directly affects the commission, but those whom we, as volunteers and residents of the city of Greensboro, have been appointed to protect in our cases as a quasi-judicial commission. So to that end, I wish to formally convey my personal thanks to former Chair Scott and his dedication, time commitment, as well as his degree of service. Former Chair Franklin Scott, thank you for your service to our residents, sir. And with that, conclude our remarks. Do I have a motion to adjourn?
Motion.
Second.
Thank you. So that motion goes with Commissioner Furlow, seconded by Commissioner McCaskill. All in favor? Aye. Any opposed? Meeting adjourned.